because again, it reopens the question that has been resolved with finality by the Supreme Court. The challenge with reopening matters that have been judicially settled is that you, by necessary implication and inadvertently, you create the possibility that confidence in that institution can be eroded. And I don't think that that would give us, in going forward, it would create a permanent state of electoral instability, because no matter who would win or lose, no matter what the Supreme Court would say, that party would say, we know. In fact, in that year, the Supreme Court said this, but when we did a forensic audit, the forensic audit produced a different outcome. Remember, ladies and gentlemen, that the work of the Supreme Court is not to declare that the election was conducted without a hitch. That is not the standard. It is not to find whether there was any hitch. In fact, since I started participating in these elections in 2013, before the Supreme Court, 10 years ago, the Supreme Court has always said there was a hitch. There was a hitch. But the standard of the law is, was there a hitch of such a substantial nature that it affected the outcome of the election? And in 4 of the cases I participated in, the answer was no. In 1, the Supreme Court said, yes, this is not good. This is not a hitch. This has gone beyond a hitch. I didn't agree with them then, but I respected that opinion and I obeyed it. And as the Attorney of the Republic, I went back and started arranging for a new election, which we did hold thereafter. One of the problems we have, ladies and gentlemen, in these constitutional timelines that are locked up in the Constitution, it confirms what the philosopher said, that the road to hell is paved with good intentions. When we wrote the Constitution here in Bomas, we thought that putting timelines by which the court must determine the dispute, we were making sure that the country would be stable, that a transition would be done quickly. We were wrong. It now turns out, in my experience, that this time is not enough. And this method that we use, this method that is by documents only, by affidavits only, and so on, is not enough. So that's one thing that if we were to reopen that process, that is one area that the experts would probably need to look at, the timelines. In fact, we almost ran into a constitutional crisis in 2017. We dodged a bullet by the sheer love of God, because Parliament had broken up, had prorogued, Parliament had gone home, it couldn't make more law, it couldn't make law to guide us, and the judges had found the night before the election that election officers had been wrongly appointed. It took the Court of Appeal sitting at night to deal with that technical problem. Where the life of the nation is concerned, we don't want those near hits. We then went into an election where I think had we missed the timeline, there would have been no government, and that's the constitution we have. If the election is not, for example, if we do an election, the Electoral Commission declares a presidential winner, a petition is filed, members of the Supreme Court are kidnapped, we do not hear the petition and finalize it within the period provided, then we have no government. I think these are very dangerous propositions, and we want to have a more flexible system. And I know there are many experts who can help us